They
Okay. All right. There's like a bright light right behind my head. Looks like I've got like a headlight. Okay, here we go. Anyway. All right. So you have an offer and acceptance. You have the offeror who makes the offer, offeree who makes the acceptance, and then you've got the acceptance. Excuse me, consideration. And consideration does not have to be for a large amount. Um, it can be, consideration of $1, depending on what kind of contract it is. But one of the keys and one of the things I think that they try to touch you on is if you have an offer and somebody sends it back and it seems to be very similar, but it has one tweak to it, it's not an acceptance because you have to accept it in the same form that it came to you. So if you write up a real estate contract, and you're making an offer on a house and then that person accepts it with all those terms, that's great. But if they don't, they send it back with, two conditions or whatever it is, then that becomes a counter offer. It's not an acceptance at that point until everybody can agree as to what the exact terms are. So just that's something that will come up on the test. Let's see. Counter offer. All right. And once a counter offer comes across, then what happens is it terminates the original offer. And then if it's not accepted, the counteroffer that comes back, if it's not accepted before the time stated, then the offer may also be terminated by the outright rejection of it. So, you got to think conceptually. You've got two sides of the coin. Which way is the contract going? And then if it goes, if an offer's been sent, it hasn't been accepted, a counteroffer's coming back. So essentially, this contract's gone. Is there acceptance on this side? That's what works for me. I mean, that's how I think about how to remember. And then it goes on and explains a little bit further. An offeror may revoke the offer at any time before acceptance. So if you offer, an offer comes in on a house, and they don't, 2 days into it, they haven't gotten acceptance, they can still pull it off the table. And it has to be communicated. Let's see. The offer may revoke the offer at any time before acceptance. Okay. This revocation must be communicated to the offeree by the offeror, either directly or through the party's agents. The offer is revoked if the offeree learns of the revocation and observes the offer acting in a manner that indicates that the offer no longer exists. For example, if a buyer gives a seller 3 days to accept the offer, and on the third day the buyer's agent calls the seller's agent and revokes the offer is terminated. So, as a real estate agent, you got to be mindful of those timelines, and you got to be really prompt about communicating whatever it is that your buyer or seller says to you with regards to that. That's got to be communicated very quickly, otherwise time can expire and it changes the time frame of what what it allows the other side to do. Consideration is something of value offered by one party and accepted by another. Consideration must be good and valuable between the parties. Another thing to think about is adequate consideration could be a promise of love and affection, or it could be a substantial sum of money. Anything that has been bargained for in exchange is legally sufficient to satisfy the requirement.
I'm sorry, what does that mean? Adequate consideration could be a promise of love and affection.
Mm-hmm. Think about if you and your kids, you're gonna make a contract with them. You make an offer to sell or give them a house. Okay. They accept it, but the consideration or the term on it is for love and affection, for the remainder of the life. I mean, in other words, you're waiving money.
Okay.
Some people you can do that.
So that's not the same thing as like selling for $1.
Yeah.
Okay.
Yeah. As we talked about, you got to have consent. Everybody has to be in agreement, and it has to be for a legal purpose. Everybody's got to be competent. Even if you have a contract, it could be, a contract can be described as valid, void, voidable, or unenforceable, and it depends on the circumstances. A valid contract, just like it would seem to indicate, has all the terms that you would need to make it legal, enforceable, and binding in court. A void contract has no legal force or effect. It lacks some or all the essential elements. If it was void, it was never a legal contract. And the example they give is the use of a forged name in a listing contract. That's going to make it void. A voidable contract appears to be valid, but then it may be rescinded or disaffirmed by both or one of the parties. They in practice, mental incapacity to enter into a contract is not the same as medical insanity. The test is whether the individual in question is capable of understanding his actions. A person may suffer from a mental illness, but clearly understand the significance of his actions. Such psychological questions require consultation with experts. An enforceable contract is one that meets all the elements, and including it complies with any applicable statute of frauds. Do you remember what that means? The statute of frauds.
Maybe. I know that, like, not disclosing something is fraudulent. I don't know.
Okay,
I'm sorry.
that's okay.
I was
Has to be in
thinking
writing.
through.
Has to be in writing. Yes, and signed. Okay, then it talks about how are we going to discharge a contract, meaning it's going to be terminated. Contracts can be discharged when it's completed, or it can be discharged because a party is in breach or default. So if the contract's been performed, then it's ended. And it talks about time is of the essence clause. When a time is of the essence clause is used in a contract, the parties should consult an attorney. The ramifications of a breach of contract in which time is of the essence can be significant. For example, a buyer might lose escrow funds, or the seller might lose the right to enforce the contract. When it doesn't specify a deadline for performance, it's supposed to be within a reasonable time, and courts can declare a contract invalid because the contract did not contain time or date for performance. So when you're drawing up, think about from, a practical standpoint. You've got a client that's making an offer. You want to put a time frame on there. Time of the essence is kind of, it means fast, but how fast, I don't know. I would, encourage you to put within 3 days, business days, weekends, whatever the case may be. Assignment means that you are transferring rights or duties under the contract. In this, it talks about a homeowner signs an exclusive right to sell agreement with a broker because the contract is for the services that a particular broker will provide. The broker cannot assign the agreement to a different broker. So if you sign an agreement with Caldwell Banker, Caldwell Banker can't turn around and assign that to somebody else. In other words, that's who you've signed the contract with. Now, if the company's bought out, you'd have to have them sign a new agreement under those terms and decide where you're going to go. Like I said, assignment is a substitution of parties. A novation is a substitution of a contract. Substitution of a new contract for an existing contract is called a novation. In the example they give here, when a real estate purchaser assumes the seller's existing mortgage loan, the lender may choose to release the seller and substitute the buyer as the party primarily liable for the mortgage debt. Or when there are many changes to a real estate contract and it's faxed, scanned, or otherwise retransmitted many times, that it totally becomes illegible. Novation occurs when a new clear contract with all the accepted change is signed by all parties. That's the sort of thing about in that circumstance, no, that's not a good example. Yeah, a novation, you're just doing a final draft of the contract. All right, breach of contract. It's a violation of the terms or conditions of the contract. A seller breaches real estate contract, the buyer may sue for specific performance. A suit for specific performance is where you're asking the court to enforce, in other words, a sale. You're asking somebody to clarify a landline, enforce the terms of a specific contract. It's not, in a typical lawsuit where you're asking for damages, money, compensation based on injury or if there's damage to your business because of the breach of contract. That's not it. That's not what we're talking about. Specific performance means you need to perform what you promised you would do in that contract. So it's an equitable remedy. Liquidated damages. Liquidated damages in a real estate contract is the amount of money in which the seller is entitled if the buyer breaches the contract. So in other words, if the buyer defaults, it may be specified as the buyer's earnest money or down payment, although in some states the amount of liquidated damages is limited to a specific percentage of the purchase price. And then a statute of limitations tells you there's only so long you can bring a lawsuit. Some other reasons you might want to get rid of a contract, it could be partial performance, work performance close enough to completion that the contract is discharged. A lot of times, like if you have a big construction job, trying to give an example, like a hospital or something along those lines, and like 85%, 95% of all the stuff has been done, you can decide to accept it as it is. It's close enough to completion, even if some of the minor elements along the lines have not been completed. You've substantially performed the bulk of the contract. Another reason it would terminate is impossibility of performance. If the house burned down, if something was destroyed, the buyer's laid off work, can't really afford it anymore, then you have impossibility, and that would be a reason to terminate. You can cancel if both of y'all agree on it, and it could be by operational law. What if you found out the contract was done by a minor, a fraud, it was altered, the contract was altered? Then those would all be reasons under the law that would not work. In practice, if a contract contains any ambiguity, the court will generally interpret the agreement against the party who prepared it. In a contract between a business and a consumer, the court will tend to favor the consumer unless it can be shown that the consumer signed the contract with full knowledge of the consent. So, if it's between one person and a big company, they're going to go with the little person. Contracts used in real estate business. When are you going to have contracts? You're going to have a lot of sales contracts. You're going to have the offer, counter offer, acceptance, binder, earnest money deposits. And I'm not going to stand here and read all the contingencies in a sale contract, but I'm telling you, please look over that. And also in your workbook, there is where you can fill out, like it gives you a hypothetical. Please be sure to review that as well. Another thing on the outline is amendments and addendums. That's specifically on the outline at the back of your upcoming test. A change or modification to the existing content. I'm sorry, page 213. Let's see. A change or modification to the existing content of a contract is an amendment. An amendment can also be a change to the existing words or provisions in a pre-printed contract form. Amendments to the contract form must be separately initialed or signed by all parties. So in practice, it says seller and buyer have agreed to a sales contract that provides for a closing with the completion of the transaction being 60 days. In the next few weeks, it becomes obvious because of the backlog in the lender's underwriting department, a closing in 60 days is not going to happen. The parties agree to amend the contract to allow 30 more days within which to complete the contract terms, executing a document that changes the provision requiring closing within 60 days to within 90 days of acceptance. So, an addendum is a provision that's added to the end of an existing contract that may change or be an addition to the content in the original. The example it gives, it might be an agreement to split the cost of repairing certain items discovered in a home inspection. Okay, I put a video, I kind of got away from doing the week by week stuff because we got off on our weeks and it doesn't follow the syllabus, so I just put unit 11 and 12. So under unit 12, there'll be a video that talks about contracts. So, do you have any questions about that? I mean, it's really a lot of terminology. Don't get tripped up on if you've got contracts going back and forth. Keep in mind where you are. I would say that would be a big thing to be looking at. In Chapter 13, one of the big things they talk about is the type of liens. And I think that on page 223, that's a good flow chart that shows you, because on the outline it specifically says liens, you gotta know voluntary, involuntary, and the priority. And it says to look at types of liens. There's a memory tip: 4 ways to create a lien: voluntary, involuntary, statutory, and equitable. What is a lien? Do you know what a lien is?
It's a charger claim against a person's property made to enforce the sale of money.
Yes, yes. And then once you have a lien on a piece of property, you got to think back a few chapters, but then you have an encumbrance. In other words, you're not going to have clear title at that point. So once an encumbrance is out there, it's any charge or claim that attaches to real property, including liens and non-monetary claims. It lessens the value or impairs the use of the real property because now it's not free and clear. There's 3 different kinds, there's voluntary, involuntary, statutory, or equitable liens. And it goes through, it talks about specific kind of liens, general liens, let me back up a minute, affect all property owned by the debtor, both real and personal. So if you have a judgment against you, estate and inheritance tax liens, debts of a deceased person, corporation franchise tax liens, IRS liens, it's a lien that attaches to real property the moment it is filed and recorded. The lien does not attach to personal property until the property has been seized. And so a general lien is going to attach to both the debtor, real, and personal property. Specific liens are going to only affect one identified property, and they only affect that particular property. So if you have a real estate tax lien, ad valorem taxes, you can have special assessment liens, mortgage, trust deed, mechanics, utility, bail bonds, and vendors. Those are things that are going to attach specifically to the property. You know, for a short little chapter, it has a lot of words. A lot of terms, that just kills me. Okay.
It is, that's why, I mean, honestly, that's what helps me is at least.
Okay, when you have liens, and we talked about tile just a second ago, the effect of it, it's gonna run with the land, it attaches to the property. If it's a lien on title, and the liens bind all successive owners until the lien is paid and cleared. So hypothetically, you've got a client, when the title search comes back and you find out there's a lien on it, you know, one or two things have got to happen. It's going to run with the property. So the seller, you know, what are they going to want to do? They don't have a lot of incentive to clear it up, but they would have already done it. So you got to decide, well, from a buyer's perspective, are you going to get it cleared up if the seller's not willing to do it? Or, you know, does that end it at that point? Because it's gonna fall on the new owner at that point if it goes with the land. All right, and then you've got priorities of liens. Generally, real estate taxes and special assessments take priority over any other liens. And I was trying to see, I think it. Let's see. Then other liens are going to follow in the order in which they were recorded. Subordination agreements between lien holders can change priority. So real estate tax liens. A general real estate or ad valorem tax. So if you've got, you know, an ad valorem tax is tax based on the value of the property. They are specific, they are involuntary and statutory liens. Okay? An ad valorem tax. Which, an ad valorem tax Okay, real estate property taxes are a favored source of revenue for local government because real estate cannot be hidden and it's relatively easy to value. Property taxes pay for a wide range of government services and programs, including those, and it gives you that whole list. Certain things are exempt from taxes. Hospitals, education, church, state and federal governments, cities, and different municipal organizations. How are they going to assess your land? They have the assessment office. First you're going to get the estimate, and then they'll put that, the estimated value will be, if you don't dispute it, then that becomes the basis for what they decide you're going to owe. I'm looking at the bottom on page 226, the tax rate. A tax rate may be stated in a number of ways. In many areas, it's expressed in mils. A mil is 1/1000th of a dollar. So a tax rate may be expressed as a mils per dollar ratio. For instance, in dollars per hundred or in dollars per thousand. Tax bills. A property owner's tax bill is computed by applying the tax rate to the assessed value of the property. So, in practice, a property is assessed for tax purposes at $160,000. At a tax rate of 3% or 30 mils, the tax owed on the property is $4,800 because you do 160,000 times 0.03. If an equalization factor of 120% is used, the computation is in two steps. You have 160,000 times 1.20 equals 192,000. Then once you come to that rate, then you multiply that by 0.03 and you get 5,760 is what is owed. How do you enforce tax liens?
Real estate taxes must be valid to be enforceable. That means they must be charged properly, must be used for legal purposes, and must be applied, must be applied, equitably
Mm-hmm.
to all properties.
Yes. Yeah, that's fine. But that's where if somebody isn't paying their taxes, it'll come out in the paper and then you'll have a tax sale. And that's where it talks about having it on the courthouse steps. When that happens, you also have what is called the right of redemption. And that would be a specified period of time that a property owner could come back and essentially satisfy the debt and repurchase their land. Okay. It goes through and talks about a mortgage lien, a mechanic's lien, but remember, a judgment is a decree that's issued by a court. And when that happens, it establishes the amount the debtor owes and provides for money to be awarded. It's called a money judgment. A judgment is a general, involuntary, equitable lien on both real and personal property owned by a debtor. To enforce a judgment, the creditor must obtain a writ of execution from the court. That directs the sheriff to seize and sell as much of the debtor's property as is necessary to pay both the debt and the expenses of the sale.